But today, Jordan's actually going to speak about something that is more relevant to what he practices. We mentioned that Jordan is a commercial bankruptcy lawyer. So hopefully none of us ever need him, and hopefully you don't have any friends that ever need him. But if one of you or your friend is going through a tough time in their business, definitely this is the man you want to talk to that can really guide somebody. What are the best moves that they can do? And if need be, that might be a bankruptcy. And the question, of course, is why do we have bankruptcy laws? Why is it that you can literally just sign on some papers and not owe any money to any person that you owed money? And I don't know if it's that simple. I think I'm oversimplifying it. But this is what our subject will be today from Jordan. Again, Jordan is a lawyer at Perkins Coie, and as he mentioned, he is the only observant Jewish practicing lawyer there. He's part of the Religious Diversity Board, and we're very honored to have you here today. So thank you, Jordan.
Thank you. And hello again, everybody. I think most of you will remember me from 2 weeks ago. I'm told by my wife that I look younger today than I did 2 weeks ago because I no longer have a white beard. So there you go. And Levi is right. I am going to be talking about the subject that I have made a career of. For nearly 30 years, I have been practicing in corporate bankruptcy work pretty much all over the country. And what I have done is prepared what I hope will be a way for all of you to get a lot more of a sophisticated understanding of the role that bankruptcy plays in our economy, the role that it plays in our society, and has since the founding of this republic. And in ways that perhaps you don't quite understand, but hopefully will by the time I finish. What bankruptcy really does is it reflects choices that we make as a society and choices that we make in running our economy so that we can avoid some of the really terrible things that happen when companies or people find themselves owing money or are insolvent in other parts of the world. And I'm going to sort of get you through that by going through the history of how we got to where we are and why you'll hear me say later that the United States bankruptcy system really is the envy of the world, and why it is that that is true and how we got to that point. But first, what I want to do is I'm going to share my screen. I think I can do that. And computer sound so that we can do all this. And we are going to start. Hopefully you can see this screen. History of bankruptcy, yes?
Yes, we definitely do.
Great, okay, excellent. So let me start by telling you what it is that today we still think we are going to be accomplishing with respect to bankruptcy. Does anybody on the line know what this photograph is of? Anybody see?
You can unmute your mics if you'd like to speak up.
If you're talking, I can't hear you, but if no one knows what this, I'm sure that many of you know who these actors are. I am pretty sure without exception, they're all gone now, but this was a photograph from a very famous movie. Some of you are nodding your heads, you're on mute, so I will, for those of you who don't recognize this, the people pictured in, the actors pictured in this photograph from left to right are Jimmy Durante and Jonathan Winters and Milton Berle, Sid Caesar, Andy Rooney, and Buddy Hackett. Sorry, I said Andy Rooney, I meant Mickey Rooney. I misspoke, different Rooney. This was, for those of you who don't know, the 1963 movie, It's a Mad, 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 Mad World. It's shown on television actually pretty frequently these days, which is surprising to me because it's a pretty old movie by today's standards. It predates my life, but it is not by much, but it does. And it's fairly dated for a lot of younger people, but it was an uproariously funny movie for the time, and won some Academy Awards, I believe, in 1963. And it featured pretty much every comedic actor known to mankind. All had small or large roles in this movie, depending on how much they were able to get. Everybody wanted to be in this movie. And the reason I'm talking about it is because when I was a law student back in the 80s, it was introduced to me. It was a movie I was already familiar with and already had seen a few times and really, really liked and still do to this day. But it was introduced to me in a remarkable way by my professor of bankruptcy law at University of Virginia Law School as a way of understanding why we have bankruptcy law. If you can believe it, I swear to you, I'm going to make you understand why I say that. It's crazy. But for those of you who are unfamiliar with this movie, the basic plot of the movie is that Jimmy Durante, who is pictured here dying on a hillside, he is seen at the beginning of the movie racing along Highway 1 in California, along the coast, and he crashes his car rather spectacularly, having passed all of the other actors' cars. None of them know each other, and he passes them all and then runs his car off the road, crashes spectacularly on the embankment, and they all stop their car, having seen him run off the road, and hope to render assistance. And with his last dying breaths, he tells them all that he has been a fugitive from the law for many, many years. And many years earlier, the loot of a robbery that he had undertaken years earlier was $350,000, and he had buried it south of there in what we're supposed to assume is, sort of San Diego area. They don't call it that. They call it Santa Rosita, but they really mean they probably mean San Diego. And he said he buried this $350,000 in this state park, and then he dies. He actually literally kicks the bucket. He kicks a real bucket, and the bucket rolls down the hill. And it's kind of a cute joke. And if you can imagine, the $350,000 was quite a lot of money back in 1963. At this point, you probably would call it $5 million to make it more relevant. And then he dies. And all of these strangers now believe him enough to say, well, maybe we could drive down to this park and dig it up. And rather than go it alone, they decide that they're going to try to work it out fairly among themselves. So the way that we can try to imagine this is as a sort of a way of looking at a bankruptcy case. Imagine that Jimmy Durante, rather than being somebody who hid the money, is somebody who owes all of these people money. He is instead the debtor in a bankruptcy situation. He owes them money, and that the passersby, played by all of the major actors in the movie, are the creditors, the people to whom he owes money. And there's only a limited amount of money available, and each creditor wants all of it. Doesn't really want to share it. They really do want all of it. And so the creditors try several ways to negotiate a fair distribution, but nothing works because everybody is trying to deal purely from self-interest. They all want all of it. They don't really want anybody else to have it, even though everybody else is just as entitled to the money as they are. And so we see this famous scene, and hopefully you will be able to hear it as well as see it, this famous scene on trying to work out exactly how this is going to go with fair shares.
Let's see now. As I understand it, I got one share for being one person, one share for going down the hill, one share for the truck, and one share for being a person in the truck. But no matter how you figure it out, I still don't get as much as anybody else.
Look, let me explain it once more. You see, their group, those three of them, they get 112,000, right? Those over there, they get 97,000. Us, we get 84,000. And you, by yourself, you get $56,000 alone. And that's tax-free money.
What do you mean, tax-free?
Well, I mean, if we go down to this park and we uncover the money and we have it, I mean, I'm sure he's not going to declare anything. I know he's not going to declare anything. And I'm not going to, declare.
What are you talking about, declare it?
Well, I mean, it's like non-taxable income. It's like a gift.
But sure, if we find the money, we still have to report the taxes. Otherwise, it's like stealing from the government.
Oh, brother, look, can you explain it to him, please?
Oh, me? Well, don't you see, if we find the money, there may not be any taxes to pay on it, just because we did find the money. But what he was trying to say is...
Listen, everybody has to pay taxes. Even businessmen that rob and steal and cheat from people every day. Even they have to pay taxes.
I give up. Look, anybody got a better, fairer plan? Go ahead and do it.
There were 8 of us there, so that simply means 8 shares. 3 for us, 2 for you.
Ah, this is hopeless. We're gonna get no place if we're gonna continue listening to this old bag.
Hey, what are you trying to do, lady? You're trying to split us up so it becomes every man for himself?
And every woman for himself?
One more funny remark from you, Buster.
Well, let's get out of
Oh,
here.
please don't argue anymore. You heard everybody's...
Look, we figured it 17 different ways. And every time we figured it, it was no good, because no matter how we figured it, somebody didn't like the way we figured it. So now, there's only one way to figure it, and that is every man, including the old bag, for himself.
So good luck and may the best man win.
Right. Except you, lady. May you just drop dead.
All right, we all agree on that. Now look, let's be sensible about this thing. There's money in this for all of us, right? There's enough for you, there's enough for you, and for me, and for you, and there's enough for me.
Oh, Elbow, my shoes!
Here you come.
And now we see what happens. They all race. That's the beginning of the movie. They spend the rest of 2 hours of movies racing through Southern California to try to be the first one. They all try to be the first one to dig up the money in the state park. They destroy everything in their path. There are whole businesses that get destroyed, broken down to the ground. Many, many more people get involved. The amount of destruction and pain and misery that they all go through, all hysterically funny, I should assure you, in case you haven't seen this movie, is the whole movie. And eventually they dig up the money. They do find the money, but they all get there at roughly the same time. They try once again to divvy it up fairly, but one person takes advantage, and all of the money is lost in it all spills out over this large crowd of people, and nobody gets anything. And so what we really see is, if we again remember, if in our head, this metaphor that we're using this movie for, is that all of these creditors, as we're calling them, all of these creditors are racing to these assets because they all want to have them to themselves. And that race is expensive and destructive and inherently unfair. And it puts creditors in trouble and ultimately much worse off than they were before they ever tried to be the first ones to get all of the assets. This is the end of the movie here, where all of them wind up in the hospital, gravely injured. They don't have any money, and all of their efforts failed and did nothing but destroy things. So this is what our United States bankruptcy regime wants to avoid. It wants to avoid a race to the limited assets of the debtor by all these creditors who are acting in their self-interest. That's all it wants to do. That race is expensive, it's destructive, and it's inherently unfair. And why is it unfair? Because every creditor is acting for itself, and that is inefficient, and it threatens to reward all the wrong behaviors that we don't want to reward. In other words, we don't want to create incentives for creditors to be selfish, for creditors to be destructive, for creditors to prevent other creditors from doing this first, to racing to the courthouse or racing to obtain possession of the debtor's assets. Those types of things are the kinds of destructive and inefficient things that we don't want to incentivize in our system. So we adopt what we call the United States Bankruptcy Code. Now that's what we have now. And I'm going to tell you about how we got to the United States Bankruptcy Code for the rest of this talk. But what I'm going to tell you about is that the United States Bankruptcy Code really has big ideas that, as I say, are the basic foundational ideas of what our bankruptcy system has always been about now for going more than 100 years, and why it is the envy of the rest of the world. The big idea is we're going to stop the race. We're not going to have creditors race to try to be the first ones to get all of it. The second one is we're going to treat everybody fairly. Everybody is going to calm down, and we're going to figure this out in a fair way. Now, it is true that some people get treated more fairly than others, and we can talk about that perhaps, but generally speaking, the reason they're treated more fairly than others, it's sort of a joke, is we as a society, Congress has deemed that when we're preferring one creditor over another, that's still fair because we like them. And I'll talk about what that looks like later. And then we give, especially companies and especially individual people, a fresh start. It means that once they go through this process, individual people are not left with nothing. They're not left destitute and unable to make a living, unable to live in a home. We don't ruin people's lives because they have to go through this process. We try to preserve people's participation in the economy. We try to preserve companies' ability to continue to employ people. We don't like the idea of ruining a business. We don't like the idea of businesses going out of business forever. And we certainly don't like the idea of leaving people with you remember the old cartoons where you have a barrel and it's held up by straps over their shoulder because they've literally got nothing left. We don't do that in our system. And that's what you're going to hear me call a discharge. So a discharge from bankruptcy means that you are giving somebody an ability to walk away from the history of bad results of their economic activity and giving them a clean slate, no more debt, and now you go and see if you can do a better job going forward. Those are the big ideas. So how do we get to these big ideas? Well, bankruptcy actually comes from very ancient ideas from back in the days of really the Roman Empire, and even before that, and we'll come to understand that in a second, of whenever money is used for commerce, that is when we need a bankruptcy system. So the word bankruptcy, by the way, there's some discussion and some disagreement about where the word bankruptcy comes from, but the first idea and the best idea is that it comes from Latin through Italian. So in Latin, bancus ruptus meant broken table, okay? A merchant's table would be broken. And that led to the Italian word banco rupto, okay? So that's sort of the best idea of where the word bankruptcy comes from in English. And the idea that is not really, there's not a lot of evidence for this, but it makes a lot of sense, is that in Florence, you would set up a table or a bench where you would do your business in the public square, and if you couldn't pay your debts, the creditors would simply break your bench and you were out of business. Literally a broken bench, a bancarotta in Italian. But we go back much, much further than that, and we actually look in the Torah and find the first inklings of where we get bankruptcy ideas from that have made their way all the way forward into the most modern bankruptcy system that exists in the world, and that is the United States Bankruptcy Code. I'm not being jingoistic when I say that. I really mean that the United States Bankruptcy Code is the highest ideals of a well-functioning bankruptcy system, and all the other countries in the world are revamping their laws to make it more like ours, not the other way around. So how did we get there? Well, we start by looking at different provisions of Torah. And we're going to see things that come from Devarim, which is the last book of the Torah, or in English, it's called Deuteronomy. And the first is what we see about the cancellation of debts. At the end of every 7 years, you must cancel debts. Every creditor must cancel the loan he has made to his fellow. He may not require payment from his fellow or his brother, because Hashem has proclaimed a remission of debts for Hashem. This is the first expression of what I called you before, a fresh start, a discharge. There were no qualifications for this. If the debt had not been paid back and the Shemitah year came, that's the 7th year, the Shemitah year comes, that's it. That's the end of the debt. It's just wiped clean. That comes from Torah. That was the word of God given more than 3,300 years ago. Way before the Roman Empire, way before the Babylonians, way before anything else we're talking about. This is the first expression of the discharge of debt in recorded human history. And discharge has always been one of the foundational concepts of American bankruptcy law. Always. And it will always be. The fundamental concept of certain personal assets being exempt from creditors comes from Torah. Remember, we give people a fresh start, but we also don't make them give away everything they have to satisfy their debts. We let them keep certain things that are exempt from the collection from creditors. In other words, no matter what I owe and no matter how much I owe you, you can't take certain things from me, because I can't be left destitute and completely at the whim and of the economy, or completely dependent on government support, for example. So 2 things we can see here. This all comes from Devarim. Do not take an upper or lower millstone as a pledge, which is a security for a debt, because that would be taking a life for a pledge. This is found today in an exemption that exists under every state law and every federal law, where your tools that you make your living with, if you're a plumber, your plumbing tools, if you're a carpenter, your saw and your hammer, those things cannot be taken from you no matter what, because otherwise you're left without an ability to make a living. That comes from Torah. And we find it in the U.S. Bankruptcy Code today. Devarim also says, when you claim a debtor, when you claim a debt from your fellow, you may not enter his home to take security for it. You must stand outside, and the man from whom you claim will bring the security to you outside. You must return the security to him when the sun sets, and he will sleep in his own clothing and bless you. This establishes not only that we should have rachmanis, we should have mercy for a debtor, but that the debtor should be entitled to dignity. That's a very ancient concept that I can assure you seems very modern, because it didn't exist in English law for centuries and centuries and centuries, but it exists today in our American law, and it comes directly from Torah. We also have today an exemption against creditor collection against personal clothing. You can't have all your clothing taken away from you any more than you can have your tools of the trade. And finally, there's a concept that we have built into our laws. Remember, I said some creditors are treated more fairly than others. In the United States Bankruptcy Code, we have a priority for employee wages. You may owe a lot of money to a lot of people, but you have to take care of your employees first. And this comes from Torah also. A little bit later in Devarim, it says, do not cheat a poor or destitute hired person who among your brothers or a proselyte in your land or in your cities. Pay him his wages the same day before sunset, because he is poor and his life depends on it. Let him not call out to Hashem against you, for it will be a sin in you. Again, the primacy of the claim of your employees to their fair wages comes ahead of your other creditors. And that's something we see absolutely in the United States Bankruptcy Code today. So you can imagine that the first enactments of bankruptcy law that we see in Western societies were not inspired by some of these seemingly very forward-looking and very enlightened ideas that we get from Torah. In fact, the Babylonians it had the Code of Hammurabi as early as the 18th century BCE, which, as you can imagine, is just a little bit after the Torah was given. Debtors were imprisoned An honest debtor could sell himself or his family members into slavery to satisfy financial obligations. And it didn't get really a whole lot better, 1,000 years later or 1,500 years later under the Roman Empire, until 326 BCE. The Roman law was that defaulting debtors would be enslaved or executed for just being debtors. By then, however, the Roman Empire did get a little bit better, and a creditor had the right of what is called vindictio bonorum, which means in Latin the ability for a creditor to petition a local magistrate for an order that authorized him to take property to secure the debt, so that other people couldn't get that property. It's like what you may hear from a receiver these days, is that, hey, this person owes me a bunch of money, and I'm afraid that what little he has, he's going to use to pay somebody else, and so I want to take it first. It's a race. Now, we don't like races, and it's why a receivership under state law in the United States has to give way to a bankruptcy case. Once the bankruptcy case is filed, the receivership is over, because the bankruptcy case stops the race. Don't forget that. Now, the Roman Empire fell. And as soon as the Roman Empire fell, the Western world stopped doing business with money. The Middle Ages throughout Europe was all about feudal economies. And so there was no money being used. And so when you're not using money, there really isn't a way that you can owe anything to anybody. Everything was a contemporaneous economic transaction. So there was no such thing as debt for probably over 1,000 years in Western society, in Europe. But as the Middle Ages gave way to the Enlightenment and eventually to the Industrial Revolution, we started to see the use of money again. And so when money started getting used, by the 16th century, in England under King Henry VIII's reign, bankruptcy laws got redesigned, because what was happening was creditors were saying, well, look, I'm doing business with these merchants and tradesmen, and I need to be able to stop them from cheating me when they don't pay their debts. And I want to be able to get their stuff when they owe me money, they don't pay me. I want to be able to get their stuff to satisfy my debt. So because money started to be used, the bankruptcy laws started to be passed by the 15th century reign of King Henry VIII. And again, this idea of discharge, the idea of giving a debtor a fresh start, did not exist under English law at this time. Remember, we saw it in the Torah, which is a lot older, but the English never caught up to this. So by the 17th century, in 1604, right at the start of the 17th century, the English laws had evolved further to deal with strengthening the rights and remedies that creditors have. Nobody cared about debtors. In fact, so much so that by 1705, punishment of debtors was still reaching its peak. And this is the language of the 1705 Queen Anne's Act, that if a person or persons so voluntarily surrendering him, her, themselves, shall afterward neglect or omit to discover and discover his, her, or their estates and effects, shall be taken and adjudged to be a fraudulent bankrupt within the true intent and the meanings of this act, and thereof being lawfully convicted, that's a crime, convicted, shall suffer as a felon without benefit of clergy. Okay, that's fancy way of saying the death penalty. You owe money to somebody and you don't pay it, you're going to die at the hands of the government. That is how the English were treating bankruptcy law in the 18th century. 18th century. Now, the English Parliament passed a new comprehensive bankruptcy law in 1732. That was during the reign of King George II. Now, this law still had debtor's prison and the possibility of the death penalty for debtors. When the American Revolution occurred in 1776 against King George III, when the Constitutional Convention in Philadelphia that passed the U.S. Constitution took place in 1787, and when the first U.S. bankruptcy law was passed in 1800. The English were still operating under, we're going to kill people that owe money to other people. law. And this is what the United States bankruptcy, this is what our founding fathers had in mind when they created the bankruptcy law for the United States. This is the tradition they were coming from legally. So on September 3rd, 1787, it was the very end of the Constitutional Convention in Philadelphia that led to the adoption of what we have today, the United States Constitution. And in that Constitution, we have what's called the Bankruptcy Clause. And that Bankruptcy Clause exists to this day. It has never been amended and has never been changed. And that gives Congress the exclusive authority to establish uniform federal laws on bankruptcy in the United States. That means that states are not allowed to pass any laws on bankruptcy. And to this day, every bankruptcy case in this country are in federal court under federal bankruptcy law. There's no such thing as state bankruptcy law. It doesn't exist. Now, it has existed in our past because if Congress doesn't act and doesn't have a federal law, then that leaves it open to the states. And we're going to see how that works. So Congress didn't even exercise its exclusive authority until 1800. 1800 is when they passed the first law. And it was very limited. Only merchants could be debtors, not just everybody. If you're in business as a merchant, you were the only one that could be a debtor under the law. And the only way the bankruptcy case could start is by the creditors suing the debtor. Okay, that's called an involuntary bankruptcy. Now, it did provide for a discharge if the debtor went along and cooperated with the process. So it did allow the debts to be wiped clean. But it still contemplated a criminal offense by the debtor. And the debtor could go to prison as a criminal for up to 10 years in prison. Now, that was repealed only 3 years later. And that left the states free, because there was no federal law, that left the states free to set their own laws concerning bankruptcy. And a lot of them did. And the 1841 Bankruptcy Act was the next time Congress acted. Okay, that was 41 years later. That's a long time in a young country's history. But it signaled, it only lasted a year, but it was a major doctrinal shift, because what happened at that point was that it shifted our focus away from a creditor idea, a creditor-focused bankruptcy law. Remember what was going on in England. It was all about the creditors. We're going to give you every right you had. The debtors go to prison or die. You get everything they have. In 1841, the United States Congress said, you know what, this is not okay. And it was triggered by what was called the Panic of 1837. That was a major economic upheaval. It was a depression, massive unemployment in 1837, bank collapses and failures. And so perfectly innocent, good people were finding themselves unable to pay their debts. It meant that there was a zeitgeist in this country that all of a sudden we realized that owing money doesn't necessarily mean a moral failure anymore. That people that owe debts should have certain protections. That it's not a crime to owe money to people innocently. That was a major shift in the way that we were thinking about bankruptcy law, and it was only happening in the United States. Finally, in 1857, there was yet another panic, another major depression 20 years later after the last one had happened. And that panic was one of the reasons for the Civil War, because the economic privation that was visited upon a lot of the industry in the United States was one of the leading factors of why the southern states became so much ready to take up arms in defense of slavery. And so as a result of that, we have the Civil War that got fought obviously for 4.5 years. And then in the immediate aftermath of the Civil War, newly impaneled Congress, which had Reconstructionist Congress people coming from the southern states, they passed the Bankruptcy Act of 1867. And that was really the first really solid federal bankruptcy law. It was championed by the northern states because they, of course, had this more progressive view of the way things should happen. Southern states opposed it because it would favor debtors, and you can imagine in 1867, you had millions of newly freed slaves. that were now free people in the southern states, and they would all have no money. They would all be debtors. And so southern states didn't want to protect these people. They didn't want them to get the disproportionate benefit of the debtor-friendly bankruptcy laws that were being enacted in 1867. But of course, because of Reconstruction and the way Congress was working at that time, the southern states were not able to overcome it, and that became law. And finally, 30 years later, roughly 30 years later, the Bankruptcy Act of 1898 was brought into existence, and this really became the permanent, solid expression of bankruptcy law in the United States, really to this day. Even though this is not the law we operate under today, the ideas in the Bankruptcy Act of 1898 really are largely unchanged to this day. The driving force for bankruptcies really remained as creditors. So in other words, you had to still see the creditors were the ones that were making things happen in Congress. They were the ones going to Congress saying, we need a good law here. We need protection. We need what's going on. And one of the things that was happening is that by 1898, there was so much interstate commerce and international commerce that creditors were saying, I don't know how to do business because I'm doing business with this guy in Kentucky, and then I'm doing business with this other guy in Tennessee, and I'm doing yet another business with this other guy in Ohio, and everybody's laws are different. And I don't know how I'm supposed to run a business this way. And so we needed a broad federal law. We go back to the bankruptcy clause in the Constitution from 1787, and Congress said, you're right, we're going to have a fully solid federal law. All state laws are wiped out and invalidated, and now federal law is going to govern all bankruptcies throughout the United States. It, for the first time, allowed debtors to affirmatively go into bankruptcy court and say, I need help. I'm voluntarily submitting myself to the bankruptcy court because I need help dealing with my debts. That was a radical departure, as you can imagine, from what's going on in our history, right? Radical departure. Finally, we get to a point now where it's not just individual people, but corporations by 1910 are allowed to file voluntary cases in bankruptcy and have their businesses reorganized and dealt with under the Bankruptcy Act of 1898. And finally, there is a whole body of experts that operate as the federal officials. They weren't judges, but they were called referees. And I still know lawyers, they're at the end of their careers, as you can imagine. I still know lawyers who trip up and mistakenly refer to US bankruptcy judges as referees because they're still used to the old regime. The old regime gave way to the new regime, which we have now, which is the United States Bankruptcy Code, which was the result of the Bankruptcy Reform Act of 1978. Okay, 1978 was when the United States Bankruptcy Code was enacted by Congress, and it is what we live with now today. Close to, what is it now, 45 some years later, that the 1978 Bankruptcy Reform Act, which gave us the United States Bankruptcy Code, was really the first time that a major bankruptcy legislation was passed in Congress, not in direct response to a financial crisis or some other type of political problem. It was just time for Congress to update and refine a lot of what was going on under the old Bankruptcy Act of 1898. And no, Jimmy Carter's presidency does not qualify as a crisis for purposes of the 1978 Bankruptcy Reform Act. Nor did the oil embargo, for example, in 1977 or anything like that. Those were important economic forces going on at the time, but it was not really the reason for the Bankruptcy Reform Act of 1978. And it gave us the bankruptcy code that we have today. And that, as I said, is the envy of the world. There are innumerable countries, not only in the West, but also in Asia, Japan, Korea, China, India, throughout Asia, throughout Europe, throughout South America, in all parts of the world now. The United States Bankruptcy Code is really the pinnacle, the epitome of a highly functioning piece of legislation that many, many, many other countries have adopted. In fact, there is a retired bankruptcy judge here in Arizona who, toward the end of his career, this is going back 10, 12 years ago, was being invited by the government in the Czech Republic and in Slovenia. Both of those countries had hired him to come and advise their legislatures how to make their bankruptcy laws more like the United States Bankruptcy Code. And that's what he was doing, and just saying, this is how we do it in the United States. And then they would just take notes, and then they would take it to the legislature and vote on it. That was so it is really a remarkable thing that we do very well here in this country. The Bankruptcy Code, as most of you know, have different chapters, and you've heard some of these before. Chapter 7, Chapter 9. You may not have heard of Chapter 9. So I'll tell you very briefly what they're all about, and then we can finish. But Chapter 7 is the traditional idea of what a bankruptcy in most of our heads really is. It's, I can't pay my debts, I'm completely bankrupt, and I'm going to let a trustee take possession of all of my assets that are not protected from creditors, the exempt assets. Everything else that's not exempt, you take it, you sell it, you turn it into cash, and you give it fairly out to my creditors, and they get what they get, and then everything's wiped clean, and I go forward. If I'm a person, I go forward and I get a discharge, I get a fresh start. If it's a company, that's it. It goes out of business, and it's the end of it. There's no discharge for a company that goes out of business under Chapter 7. Chapter 11 is this wonderful invention of the United States Bankruptcy Code. And Chapter 11 is an idea where companies, not individuals, but companies, will use Chapter 11 to reorganize, to find a way to satisfy the debts of its creditors without going out of business, without liquidating its assets, and to reorganize its assets to preserve jobs, to preserve business relationships, to do all the things that we want the optimal result to be, because it's not good for our economy when good businesses go out of business. People lose their jobs, value is lost, assets are brought from value to less value when that happens. So Chapter 11 is this wonderfully innovative idea to not accuse companies of being morally bankrupt when they're bankrupt, and simply say, we're going to find a way for you to get through this. Some of our most famous and most profitable companies in this country have been through Chapter 11 bankruptcies over the years. Airlines have been through 2, 3, or even 4 of them over the years, and it's okay. Again, the rest of the world is looking to find ways to make Chapter 11 a reality in their countries. Chapter 13 is for individual people to do something very similar. They find a way to make all of their debts get paid over time using their ongoing wages. So if you're a wage earner and you're earning a regular income, that regular income can be used over the course of 5 years to pay your creditors, and then anything that they don't get, then you get your discharge at that point and you're clean. Chapter 9 you may have heard of. It's very specialized, it's very rare, but Chapter 9 is used for cities and counties. So they're called municipalities, and for little divisions of those counties, like a water district. It's a very special type of proceeding. It's much more difficult to go into than we're going to do now, but suffice it to say, there have been some cities that you've heard of that have gone through bankruptcy in Chapter 9, most specifically the city of Detroit. Detroit, Michigan, very famously a few years ago, went through a Chapter 9 bankruptcy and really, really, really helped the city try to turn the page. And there is a lot to be optimistic about the future of the city of Detroit. Finally, Chapter 12 is special type of protection and cases for farmers and fishermen. And that is used there, as you can imagine. So what's next as we finish up here? What's next? Well, one of the things that's next is by even further improving the wonderful United States Bankruptcy Code. And I don't want you to think that I'm Mr. Rah-Rah about everything that Congress does. I assure you I am not. But I still do believe that the United States Bankruptcy Code in the main is really a terrific piece of legislation that works extremely well, but it can always be improved. Senator Warren from Massachusetts, she's very famous these days, she ran for president, and she is the senior senator from Massachusetts. She is a former bankruptcy specialist and taught bankruptcy at Harvard Law School for many, many years. I've known her for a long, long time before she was a senator, because she was in this weird bankruptcy world that I live in, and I have spent time with her. I have spoken with her on panels, at conferences. Nobody is smarter than she is about this stuff, and she has proposed sweeping reforms to the United States Bankruptcy Code that would even add a new chapter. She's calling it Chapter 10, that would give individual people much greater flexibility in finding ways to pay back their debt without the shame and without the damage that is done to them even today by filing a Chapter 7 bankruptcy, but also finding ways to discharge some of the debts that are very, very, very difficult to get rid of these days, and that is a real huge drag on our economy. Some of you may have heard bankruptcy being bandied about in the popular media now because of the student debt problem that we have. So we have an entire nation filled with people who owe an intolerable amount of student debt that simply cannot get rid of it. No matter how much they're employed, no matter how much money they make, they will never make enough money to pay back the student debt. And that is a huge economic problem for our country. Even conservative Republicans recognize that that's a big problem. So there is some real hope that there can be a bipartisan approach to the bankruptcy code that would eliminate how difficult it made it. Congress made student loan debt almost impossible to get rid of in bankruptcy by amendments to the bankruptcy code that were written in 2005. Now, the reason Congress passed the 2005 amendments, this was 15 years ago, is because it was the worst example of corporate ownership of Congress that you will ever see at play in our society. Bank of America wrote the law, took it to Congress, and Congress passed it without asking questions. And Bank of America cared about two things. They cared about the student loans that they had made, and they cared about the credit cards that they had issued out to literally millions of people, just dishing it out like they were dealing cards in Vegas. And then they went to Congress and said, I want you to make the loans we're making to students and the loans we're making to credit card customers impossible to get rid of in bankruptcy. And Congress said, okay. And they did. It's a bad law. Even Republicans now think that it's a bad law because people are struggling and companies are struggling because of all of the economic problems associated with this long-term debt that hangs around these people's necks like an albatross. So that's probably going to get changed. But Congress makes choices all the time, and we find them throughout the bankruptcy code. I won't go into all of them, but there's two really good examples of this. The first also happened in 2005, and we call it the Enron example. For many, many, many years, it was impossible for Congress to pass a law that made it impossible for people to do the following. Here's what people would do. In states like Florida and Texas and Oklahoma, those three states particularly have what are called unlimited homestead exemptions. It means that no matter how much money you have invested in your personal home, no matter how much it is, that is protected from the claims of creditors, even in federal bankruptcy court. So what people would do is they would get themselves in huge financial trouble, and before anybody could get anything from them, they would take every penny they had and buy a $40 gazillion house in Dallas or in Boca Raton, Florida. And then they would go into bankruptcy and their creditors would get zero. They'd get a discharge and they'd walk away free, and they would live the rest of their lives on the value they have in their house. And the reason that they could do that is because the states determine the exemptions, not federal law. And those states have unlimited exemptions. Well, the most spectacular example happened in 2004, which was Enron. And we all remember these criminals that ran Enron into the ground, and all of them went to prison. But before they went to prison, because they were criminals, not because they were debtors, they owed money to everybody, and they bought $1 trillion houses. Like Ken Lay bought a huge house, and tried to take advantage. And so Congress said, well, that's it. We can't stand it anymore. And they changed it. So now you can't do that anymore. They changed the law. And if you buy a house within 3 years of your bankruptcy filing, you don't get an unlimited homestead exemption, even if your state says so. That's an example of Congress responding to a political and economic problem with our bankruptcy law. Another example we talked about is the credit card debt. We make choices, Congress makes choices all the time with our bankruptcy laws. And it's why bankruptcy is much more relevant to all of us than just who owes money to who. It's a big deal. Bankruptcy remains a big deal in our country because it is one of the most powerful tools we have to make improvements in the way that our economy works. The development of bankruptcy law over the years is critical to the development and the advancement of trade and commerce in the Western world. So that's not going to stop being true anytime soon. And it reminds us, of course, of the whole reason why we have a bankruptcy clause in our Constitution, in our founding document as a republic, that goes back to 1787 and the Constitutional Convention. And one of the people that was there at the Constitutional Convention, who was probably more responsible for the content of the Constitution than any other person, is James Madison. And James Madison said, the power of establishing uniform laws of bankruptcy is so intimately connected with the regulation of commerce and will prevent so many frauds where the parties or their property may lie or be removed into different states that the expediency of it seems not likely to be drawn into question. And he was right then, and it's right now. Nobody questions how important bankruptcy laws are for our economy, for the way we do business with one another, for the trust that we have when we go into a store or we hire a landscaper for our backyard. In the background, even if we're not aware of it, bankruptcy law affects every financial transaction we do in our lives, whether we're spending money or whether we're being paid money. It is that important. And it's why we pay attention to this stuff. And it's why, even though it may have seemed boring to you, I hope that I have made it much more interesting to you. So thank you for listening. I'm happy to answer any questions you have.
Thank you very much. I'm going to start with the question, and then, of course, if anyone does have any questions, please do unmute your mics or use the chat. And I know that Rena already made a mention about the student debt, just an idea that she has. But what are the shortfalls? Or in other words, when you see cases, like, where do you think the system goes wrong? Or do you ever see the system going wrong?
Generally, are there things that are going wrong in bankruptcy right now?
Words, like when you look at it in typical corporate bankruptcy.
Yeah, there are some things that definitely could use some improvement. And it's not just that it turns out that some of our political choices that have made their way into the Bankruptcy Code have turned out in hindsight to have been poor choices. So the inability to discharge student debt, that was a bad choice. And most people think it is, and it's going to get fixed. I'm confident it's going to get fixed. The inability to discharge credit card debt was a bad choice based on a lie. It was based on this notion that everybody was getting these credit cards and laughing maniacally as they would go to the mall and charge up a limit and never pay back. That's just not happening. It didn't happen. It's not reality. So it was based on this fever dream that banks had of their customers, and it just wasn't happening. Most people realize that's not good either. There are problems that have to get fixed systemically. One of those problems is, and this is really technical, and it's not something, by the way, that has uniform agreement. Some people disagree with me about this. But one of the things that was created in 1978 with the advent of the United States Bankruptcy Code was an office that is a subsidiary office. It's an administrative sub-agency of the United States Department of Justice, and it's called the United States Trustee's Office. And they form, they basically play, it's an army of lawyers throughout the United States that are all government lawyers, and they provide what is supposed to be sort of an oversight function. The problem is that like so many governmental agencies, they are constantly looking for ways to expand on their mission. You know, give a cowboy a rope, an inch of a rope, and he wants to make it a lasso. So, you know, this is what's happened over the last 40 so years with the United States Trustee's Office, is that they have occupied way, way too much in bankruptcy cases, and they wind up costing the cases way, way too much money. They are destructive. They're not malicious. They're insinuating themselves where they don't belong because they can. And so that is a problem that I believe has to be dealt with. The other major problem that is inherent in our bankruptcy system has to do with the bankruptcy judges themselves. These are experts. These are good, well-meaning people. They are also not federal judges in the way we think of them. So for some of you may know, all federal judges have to be nominated by the President of the United States and confirmed by the Senate. That's not just true of Supreme Court justices, it's true also of every federal judge, circuit courts of appeal judges, and United States District Court judges. Bankruptcy judges are not appointed like that. They are appointed by a completely other process, and they don't serve lifetime terms like every other federal judge. So as a result of that, there's a limit to what bankruptcy judges can and cannot do in their courtrooms. And sometimes things that have to get done in a bankruptcy case have to get shunted up to the district court judge who doesn't know anything about bankruptcy to be resolved in the United States District Court, and they hate it. And it's a very bad system. It would have been much better if in 1978, bankruptcy judges, when they were created as full-fledged judges under the Constitution. Then that wouldn't happen. So we have experts that sometimes don't get to do the things that they're expert in because of this constitutional problem. And it's much more complicated than I'm making it, but suffice it to say, these are some of the things that keep bankruptcy lawyers like me up at night, because if we had a magic wand, we'd fix it. But it takes Congress to fix it, and it's not going to get fixed.
Right. Okay. Judy, you had some questions, but someone asked me privately, how many times did Donald Trump declare bankruptcy? I'm not sure if you're read up on this.
Donald Trump has never declared bankruptcy personally, but I would say a solid dozen or more of his businesses, casinos, the businesses that he was the principal shareholder in, have gone through bankruptcy. Most of them, I think virtually all of them, liquidated and went out of business, did not reorganize. They were true failures in that sense. But I will tell you, I am no fan of Donald Trump at all, but I will tell you that I don't like it when everybody says, you know, he's, as an indicator of his moral failings, so many of his businesses failed. I don't think that that's fair. I think that many very honest, very capable, talented business people have run businesses that have failed and have needed to file bankruptcy cases over the years. And I don't think that it's a moral failing of anyone. I think that you should look elsewhere, and you can do so successfully, in my opinion, for other indicators of his moral failings. But the fact that he was the principal shareholder of certain businesses that failed is not an indication of his moral failings. It might be an indication of his acumen as a businessman, but that's a different answer.
Thank you. All right, Judy, go for it.
Okay. Jordan, thank you very much for coming back again and both entertaining us and providing intellectual stimulation. So I'm going to go back 40 years from now, when I was the manager of the student loan department. And I did this both at, I was in the student loans both at MIT and Providence College. MIT is one of the biggest engineering colleges in the world. People on this coast don't hear of it for some odd reason, but it's in Boston.
And Providence College is the second finest institution in Providence, Rhode Island. And I say that jokingly because I went to Brown.
Okay. When I was there, I actually created the department. They didn't have one at the time, but I'd look out my office window and it was just a sea of redheads. They were all Irish Catholics, and it was run by brothers, but it's all changed now. At any rate, back in the day, I would tell these students, you know, when you're taking out a loan, you're making a purchase. So if you can afford a Pinto, don't go out and buy a Mercedes. So I feel that the person has to have, you know, make a judgment, him along with the parents, need to counsel them. They could go to a state school and transfer in 2 years and get the degree from, you know, more of a prestigious college. They also could do what Northeastern did, you would work for a couple of years and you go to school for a couple of years, then take a year off and work full time to gain the money for the next couple of years that they needed. It was a work-study program.
Right.
So I won't say that I don't have sympathy for the student loans, but I will say when Elizabeth Warren wanted us to give the student loans, I felt like strangling her, because that wasn't the beginning of the problem. And
right. Thank you for that. And I think that what Senator Warren is reacting to, which doesn't easily, you know, filter into a 20-second soundbite, is a much more complicated question and really does speak exactly to what you were just speaking of, which is that one, but not the only problem with student loans is that you have unsophisticated people who don't appreciate what taking a loan really is and the long-term economic implications of what incurring debt is all about. It's the same problem with credit cards. It would astonish all of you if I were to tell you how small a minority of Americans, adult Americans, who understand that when you use a credit card, you are taking out a loan. A small minority of Americans understand that. And so that lack of sophistication is not the problem of the bankruptcy laws. It's the problem of our educational system. It's the problem of our the way that we deal with. There's 1,000 reasons why that's true, but no one is suggesting that student loans should just be wiped out all the time in every situation. No one is saying that. It sounds like people are saying that simply because of the way that things have to get digested in the political discourse in 20-second sound bites. But what's really being proposed is simply making it easier and not, as it is now, impossible for well-meaning people who did understand, who did take the loans responsibly, who have had a change of circumstance in their lives, and they're no longer able to pay that loan back no matter what they do. People that are disabled, people that are sick, people who have a degree in something that is no longer employable anymore, people who have...
There were always loans that were written off because of an inability to pay debts. Now, as I say, I'm out of it 40 years, but I'm sure that still exists. The other problem is that a lot of these monies that were lent out were from revolving funds. So if they're not paid back, the money wasn't there for the next set of students.
Right.
So, it's a very complicated thing. I want to ask you a question, though, because we probably could go back and forth on this for a long time. I mean, it's part of the American thing to talk about all materialism and everybody has everything. So it's the responsibility of the advertisers, too, that get these people in debts. And, so they have to buy all these different things. But it used to be the case that if somebody declared bankruptcy, that went into the 3 major credit reporting agencies for 7 years, and then it was removed. Is that still the case?
Yes, it is still the case. 2 things to say about that. It is true that has never been that has never changed, and it is poorly appreciated at this point because there are still too many people who have an unsophisticated or an uninformed idea about the way bankruptcies work and think that it's very easy for somebody to go in, wipe their debts out, and walk out scot-free of bankruptcy, and everything is wonderful, and they move on in life, and nobody ever knows about it. It is very, very untrue that is what happens. an individual person that goes through even a successful bankruptcy, even a bankruptcy that is caused by nothing more than the most innocent failure of their ability to pay their debts, those people are going to live a life that is terrible in the sense for the next 7 years, in the sense that they are not going to be able to get credit. They're going to have to pay deposits if they want to open up, a phone line. They're not going to be able to get anything other than a prepaid mobile phone account. They're not going to be able to get anybody to turn the electricity on in their new apartment without paying a cash deposit. They're not going to be able to get many landlords to ever rent to them ever. They're not going to be able to get certain employers to hire them ever. It is a bad, bad deal when they go into bankruptcy because, as you say, Judy, the three major credit reporting companies will all have that very big black mark on that credit report for 7 years. Now, yes, it's true. After 7 years, that has to wipe away. That didn't come out of nowhere, by the way. You heard 7 earlier in my talk today. That comes from Torah. 7's a big number, and we get it from the Shemitah year of 7. I really honestly believe that tradition, Congress people didn't just pick 7 out of nowhere. They picked it because that's the tradition we have. 7 cures problems. So yes, it is true that mistakes that we made, we should not pay for forever. But for those 7 years, people that go through bankruptcy cases pay dearly for that privilege. And it is.
It prevents people from keep declaring bankruptcy.
Yeah.
You know, because then it would be a loophole where they could
Correct.
just go out and do all these things,
right.
And then
you can't. We call them serial bankruptcies. You can't, as an individual person, you can't do that. Companies can do it all the time. Companies can go in and out all the time, but individual people cannot.
But I heard that you would be able to get a credit card because you can't declare bankruptcy again. And they know if they give it to you, you have to pay for it. Is that true or not?
Yeah, well, the financial decision that is made by credit card issuers would shock you in that they are not making any credit-worthy decisions with respect to most of their products at all. They know without a shadow of a doubt that sometimes 85 to 90% of their credit card carriers for a particular credit card product are going to go into failure, are going to fail, or going to default, and they don't care. They've already built that into their profit, which is why I get so angry when I talk about this, because you have credit card issuers who were issuing credit cards like candy on Christmas, knowing that they were already pricing these failures into their product and they were already still making a profit. And then they were going to Congress and saying, you should pass laws that make it impossible for the people that do fail to go through bankruptcy and get rid of the debt. You should make it impossible. So the way I see this is, for example, you go into a store and you go into like a bodega, or you go into a corner market or a Circle K, and you want to buy a candy bar. The price of that candy bar is, let's say, $1.20. A part of the price that you pay for that $1.20 is profit. Another part of it is the loss associated with somebody coming in and stealing another one of those candy bars and shoplifting. You're paying for that. So that's the same with credit cards. They're already building into their profit the notion that people will fail on these credit cards. They're not doing a creditworthiness check the way that banks are when they're making a loan for your house. That's a major undertaking to figure out your creditworthiness. Credit card companies don't do that. They never have and they never will. So they don't really care whether you've had a bankruptcy in your past. It just means that they get a rough idea and they give you a very high risk, very high rate credit card. And if you don't pay it all back in the month, you are already on your way to financial ruin because it carries a 27% interest rate, which is loan sharking in my view.
One other question, if you will. So let's say somebody's very wealthy before they go into bankruptcy and they own several expensive cars and a very expensive home. Do they get to keep all of those assets?
No, they don't get to keep their cars. Those cars are going to get sold. The home, their principal residence is entitled, this is what we spoke about before, their principal residence is entitled to a homestead exemption. That is true throughout the United States, and every state has different levels of homestead exemptions. In Arizona, for example, you have $150,000 worth of equity in your home. So above, if you have equity in your home, you may not. But if you own your home and it's worth at least $150,000 more than you owe on it, that's equity, and that is protected from creditors. And usually what that means is your home won't get sold under you and give you cash. You'll be able to keep your home. If you have vacation homes in Cape Cod or in Myrtle Beach or in Newport Beach or whatever, if you're that wealthy and you have other homes, those homes are not protected by the homestead exemption. And if you are really in extremis and you own a lot and you owe a lot of money to a lot of people, those are going to get sold like anything else.
Thank you. Stan, you had a question.
Yeah, I have a couple of things. I do mentoring for SCORE, and we have people who come in and want business advice, and you'll say, are you in debt? And I say, no. I said, what about credit card? Oh, I own $37,000 on my credit card, but I'm not in debt.
Exactly.
I mean, it's like no clue. The thing that I wanted to ask was, you can still foreclose on a home, though. A bank can foreclose on somebody's primary residence.
Yes.
Because they haven't declared bankruptcy, or?
No, it has nothing to do with bankruptcy, and it really doesn't have anything to do with exemption. So the idea of foreclosing on the home is you are entitled to the value, as a creditor, you are entitled to the value of your home that is in its equity. So most foreclosures, as you can imagine, there's a foreclosure because the house is not worth what the debt is. It's underwater, as they say.
Yeah.
So if that's true, you don't have any equity, and therefore there is no homestead exemption because you have no equity. The homestead exemption doesn't protect the house. It protects the equity in your house. If you don't have any equity, there's nothing to protect. So the foreclosure, they're going to take your house and they owe you anything. If you do, however, have equity, let's say that you owe the bank $100,000 and the bank thinks your house is worth 90 and forecloses because you're in default on your loan, but then at the foreclosure sale, somebody bids $120,000 for the house. That extra 20 that is now not owed to the bank is yours, and you get that. And your other creditors, by the way, if you have other creditors, can't attack that 20. That 20 was your equity and is protected from all creditors, not just the bank, from your creditors under the homestead exemption. That's how that works.
If I declare bankruptcy and I owe the government taxes, sales tax and whatever, that money comes out first, doesn't it, before anything else is settled?
Not before everything, but taxes are given. So if you remember my little joke a while ago about how some are treated more fairly than others, the Bankruptcy Code has certain types of debts that are given priority over other debts. Taxes are one of those debts. Wages that you owe to your employees is another one of those. Child support is another one of those. Spousal support is another one of those. If you have damages associated with things like drunk driving or sexual abuse, those things are given priority. There are certain categories of debts that get paid before anybody else does.
Now, is that
yeah. Now,
dollar for dollar, and then close like 10 cents on the dollar, or that could be also 50 cents.
It depends. Those are all what we call unsecured debts. Okay, so when you're talking about a bank that has the mortgage on your house, that's a secured debt. They're not even in line because they have access to assets.
Yeah.
Your creditors, like your taxing authority or your employees, they don't have access to your assets. They're just owed money. That's why they're called unsecured. Once the secured creditors are taken care of because they have had access to their assets, then anything left over then goes for distribution to all of the unsecured creditors. And everybody's supposed to get it equally, except the people that get priority. They have to get paid in full first before anybody below them gets anything. And sometimes that doesn't happen. Sometimes even the people with priority only get cents on a dollar, and then anybody below them gets nothing.
I look at student loans as you become an indentured servant.
Yes, and the reason for that is not because student loans are given priority or not priority. It's because of the exceptions to what we call the discharge. That fresh start that you get, there are certain debts that you can't get a fresh start from no matter how many times you go through bankruptcy. And again, these are political choices that Congress has made. So drunk driving damages, you can never get rid of them. If you commit medical malpractice, you can't get rid of those debts. Certain taxes you can't get rid of. Certain, not all. Income taxes you can get rid of, but some taxes you can't get rid of. Certain just bad things. Okay, any debt you've incurred by actual fraud, if you've defrauded somebody and now you owe them money because you defrauded them, you can't wipe that out through bankruptcy. Student loans were made recently one of those debts that you can't wipe out no matter what you do. And what people are saying is that's just not fair. There's not, I mean, fraud, drunk driving, murder, those are the things you don't want to wipe out with bankruptcy. Student loan? Really? It's that morally suspect? And that's sort of the problem. That's what we're talking about. That's why it feels like indentured servitude, because any debt you have that you can't get rid of at all, ever, will always hang around your neck like an albatross. It's like a disease. And so one of the things that Senator Warren was talking about a few years ago, when she ran for president 4 years ago, was talking about things called debt zombies. And she points to very important statistics that not enough people, I think, are aware of. When you look at individual people in the United States who have filed bankruptcy, 70% of them filed bankruptcy because they are crippled by debts associated with healthcare costs. They got sick. That's it. They got sick. Or they had an accident. They were hit by somebody in their car. This isn't a bunch of people running around and being irresponsible. This isn't a bunch of bad doers. These are people who are the victims of illness, that they are victims of a job loss, that they're a victim of getting hit by a drunk driver. And that is what our bankruptcy system is helping these debtors do. And if we make all of these debts that these people have completely impossible to wipe out through bankruptcy, then they walk around the rest of their lives like zombies, because they will always owe money to people and they will never, ever have enough money to pay it back. You can tell me whether you think that's a good idea or not. Most people don't think that that's a good idea. And it's becoming less and less of a political issue and much more about what are we supposed to be about in this country? Do we want people to just be in debt for the rest of their lives through no fault of their own? Not enough people are saying yes to that. And that's why I think our bankruptcy laws are going to change a little bit.
Thank you. I see 2 more questions in the chat, and then we can wrap it up with that. What is the length of time that a person has before they can declare a second bankruptcy?
It's a complicated answer, unfortunately. I'll give you a simple answer, which is it's usually 7 years for an individual, but it can be as short as 3 years, depending on the kind of relief that that person got. There is, as I said, with companies, for non-individual debtors, for businesses, there's no limit. They can file and file and file as frequently as they like. But for individual people, there are limits. They can file sometimes, but it means that they don't get a discharge. If they've gotten a discharge too recently, they can file bankruptcy again, and it can help them do certain things, but they don't get a fresh start.
Okay, and then the second one was there any particular case that annoyed you due to a loophole in the bankruptcy laws? And we'll end with that question.
That's good. Good question. A loophole. Well, yeah, I mean, I think I talked about it. I think I talked
exceptions, right?
Yeah, I think I talked about it. I think I saw, look, personally, I knew of a physician when I was in college. My parents lived in South Florida, and they became friendly with somebody. And that somebody used to be a physician practicing in a large city in the Northeast. And that person was not a particularly capable doctor, unfortunately, and had numerous malpractice actions filed against him. And he was sued repeatedly by his patients who had been very badly damaged by his poor medical care. And he owed tens of millions of dollars in judgments. So he sold his medical practice for millions of dollars in the Northeast, moved to Florida, immediately purchased a home for like $7.5 million, this amazing luxury mansion, and then funded funded individual retirement accounts for his 3 children in hundreds of thousands of dollars, and then declared bankruptcy. The bankruptcy got his creditors absolutely nothing, $0. And he lived like a king in South Florida with all the respect and admiration that people in South Florida give to people who they perceive to have money, and went through the rest of his adult life and into his old age with everybody saying, look at this macher with all this money, and he gives to Federation, and he's this big, he was a Jewish man. And even then I felt like that was a loophole in the bankruptcy law that allowed him to take advantage of an unlimited homestead exemption and the exemptions that are honored under the Bankruptcy Code, allowed him to wipe out all of his debts to all the people that he rightfully owed money to, and then live like a ganze macher in South Florida for decades. And to say that that is a Chilul Hashem, it's a shameful, shameful thing. And it makes me angry, as you can tell, to this day. And that is a loophole that thankfully was closed in 2005 by amendments to the Bankruptcy Code. He would not have been able to do that today.
Yep. I'm not surprised.
Well, thank you so much for this very informative presentation on bankruptcy.
Good job.
And also how you, I liked the part, you know, where you see the future of it as well, which is quite interesting. So thank you.
Well, I am pleased again to see so many of you, and I'm glad that I was able to hold your interest and elicit some really excellent comments and questions from all of you. So thank you. And a Freiliche Hanukkah for all of you for the rest of the Chag.
Thank you.